A rare 4-4 deadlock at the Supreme Court when it comes to a religious charter school in Oklahoma, a major First Amendment issue. Let's discuss. I'm Dave Aronberg, former state attorney for Palm Beach County, a.k.a. the Florida LawMan here on Legal AF. Thank you for all your support. Keep hitting that subscribe button. We appreciate it. We're over 600,000 plus, and we're going to keep rolling. So let's talk about the Supreme Court, an evenly divided Supreme Court, 4-4. On Thursday, decided to reject a plan that would have allowed Oklahoma to use government money to run the nation's first religious charter school. This is a Catholic school, strict Catholic curriculum. What's interesting is that the swing justice, Amy Coney Barrett, remember, she's the one I did a whole video about how we should give her due. She has broken away from MAGA world. She has been very independent. She's very Catholic. In fact, when she was nominated, she was seen by some as part of a cult where she was so right-wing in strict Catholicism, but it hasn't turned out that way. But when it comes to this issue, people were watching her on this because she is very religious and to see where she would come. Well, she's the reason why it's 4-4, because she recused herself from the case. We were wondering what she would do. Well, she recused herself, and that's why in her decision, by the way, it's up to her to decide whether to recuse herself. Clarence Thomas has these conflicts of interest and does not recuse himself. He votes regardless. So I do give her props for recusing herself from this matter. And as a result, the Supreme Court voted it down, 4-4. You got to have a majority, and that's not this. So that's a victory for people who believe in the Establishment Clause of the First Amendment. Remember, the First Amendment has two clauses that are in conflict with each other, at least tension with each other. You've got the Free Exercise Clause and the Establishment Clause. One says the government can't prohibit the free exercise of religion that is used to promote religion in certain spheres and limits government involvement. And the other one is the Establishment Clause, saying government cannot have an establishment of religion. So you can have free exercise, but you can't have the establishment of a religion. And these two portions of the same First Amendment work in conflict with each other. And here, the Establishment Clause wins out. And if you're wanting for reasoning, well, there is none. The Supreme Court decided 4-4. They didn't provide a reason. According to the New York Times, the deadlock means that an earlier ruling by the Oklahoma Supreme Court will be allowed to stand. The state court blocked a proposal for the Oklahoma school, St. Isidore of Seville Catholic Virtual School, which was to be operated by the Archdiocese of Oklahoma City and the Diocese of Tulsa, and aimed to incorporate Catholic teachings into every aspect of its activities. Now, if this were a private school, there'd be no issue. But it was going to be a public school, a public charter school. And that's why there was an issue. People thought this would break down the barrier between church and state. But not yet, because according to the New York Times, because there was no majority in the case, the court's decision sets no nationwide precedent on the larger question of whether the First Amendment permits states to sponsor and finance religious charter schools. The decision did not include a tally of how each justice voted, stating only that the lower court ruling was affirmed by an equally divided court. Justice Barrett did not explain her recusal, though she is close friends with an advisor to the school. And if I had to predict which way the justices went, well, we always can predict Alito and Thomas, right? They're very predictable. They're going to be on the side of far right-wing stuff whenever there's a issue involving politics or religion. Well, so they're on the side of allowing the school to continue. And then you have the progressives, the three. You have Kagan, and you have Ketanji Brown Jackson, who I know from high school, college, and law school. Amazing person. And you have Sotomayor. So you have them on this side. Now you have the Chief Justice Roberts, who is a swing justice generally if it's not Amy Coney Barrett, and he's going to likely be the fourth justice because the other two justices would likely have gone with Alito and Clarence Thomas. That's Neil Gorsuch, appointed by Donald Trump, who is pretty much stuck to right-wing ideology. And yet Brett Kavanaugh, again, appointed by Donald Trump, who, although occasionally will show some independence and go along with Amy Coney Barrett, generally sticks to MAGA and other right-wing ideological issues. So I would think that the deciding judge here would have been Chief Justice Roberts. He strongly believes that the public should buy into the court as an apolitical court. He feels uncomfortable uprooting huge precedent. That's why, even though he is supposedly anti-abortion, he voted against the overturn of Roe versus Wade. He thought that was a bridge too far. It was a 5-4 decision. Amy Coney Barrett, by the way, voted with the conservatives, and that's why it was 5-4. I don't give her a pass on that. But on this one, it looks like the deciding vote was Chief Justice Roberts, 4-4. According to the New York Times, across the country, charter schools are public schools that are run independently, sometimes by nonprofits. St. Isidore had sought to challenge their status as public schools, arguing that it would instead be a private school, but in contract with the government. So this is essentially, though, is still a public school. If you're in contract with the government getting public dollars, are you really still a private school? The question is likely to come before the court again in the coming years, giving the justices the opportunity to weigh in again in a more definitive way. The court's conservative supermajority has often been receptive to allowing religion a greater role in public life. And yes, that's the thing. That's why a lot of us were surprised that it became 4-4, because the right-wingers on the court generally have their way when it comes to issues like religion. It's a 6-3 conservative majority, and somehow, because Amy Coney Barrett recused herself and Chief Justice Roberts apparently went with the progressives, that didn't happen yet, at least not for now. Supporters of public education and the separation of church and state quickly applauded the decision. Mainstream advocates for the nation's 8,100 charter schools had also opposed the creation of a religious charter school, which they said defied the original intent of charters. Starlee Coleman, the president of the National Alliance for Public Charter Schools, said charter schools were created to be public alternatives to traditional district schools, offering new options to families while still being held accountable to the public. That's what makes them special, and that's what we're here to protect. The charter school case was one of 3 important religion cases heard by the justices this spring, a test of the court's vision of religious liberty, which had been one of its most prominent focuses in recent years. And in a paragraph in the New York Times, it validates my assumption that it was Chief Justice Roberts that sided with the 3 progressives. During oral arguments, the justices had appeared to be divided along the usual ideological lines, with the Republican appointees seemingly sympathetic to the school and the Democratic appointees skeptical. Chief Justice John G. Roberts Jr., a Republican appointee, however, asked questions supportive and skeptical of both sides, raising the possibility that he might enter an alliance with the court's 3 liberal members. And what is so interesting is that in recent years, it was Chief Justice Roberts who has written with the conservatives, written the majority opinion on religious issues, lowering that bar between church and state, lowering that divide. And I think that had to surprise people now that he said, no more. We're not going to go any further as of yet. He could have. He's a swing justice, but he decided that enough was enough for now. And perhaps it's because the public has lost faith in the Supreme Court, thinking that they've become a political body. And now Roberts, in recent rulings, has worked hard to try to reinstall the faith. I mean, after the immunity ruling, I think the court has reached its nadir in public opinion. But what you've seen recently in, for example, some of the rulings on Trump's deportation policy is that the courts are pushing back. They become a guardrail. And perhaps now Roberts thought it wasn't a good time to eliminate that line between church and state. So he gave the Establishment Clause folks a win. The separation of church and state folks a win. And he may have made some members of MAGA cry. That's the latest here on Legal AF. Thank you for all your support. Thank you for watching. If you like this video, please like, subscribe, share with a friend, leave a comment below. I'm Dave Aronberg, aka the Florida LawMan, and I'll see you next time.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.